item 11, first April 367 of 2018.
एक चीज और लिखिएगा इसमें सुनिए. It is not in dispute that the property involved in this case is relating to ward number 4, falling in Ranchi municipal area. Exhibit 4 relates to ward number 5 and 6 dash Doranda, and exhibit 12 relates to ward number 3. चलिए.
Last judgment.
Yes.
Because from my perspective, because one judgment can be read from different directions. So what I want to indicate,
Big judgment.
it is Narendra Kumar versus State of UP 2017.
It is included in your comparative.
It is a part of competition. That competition.
वो उन्हीं के पास है. आपका वाला आपके पास है. ये वाला आपको वापस कर दो, पुराना वाला. इसमें सर कुछ बैकग्राउंड वगैरह आप दिए होंगे, क्या दिए हैं आपसे?
Submit the written argument and we will take out the judgments that were given.
Furnished.
That were
Yes, I can just retain the written
Yes,
submission.
yes.
Right?
And today whatever we have given the judgment that are the final judgments.
इसको जो है ना चलाने दीजिए, देखते हैं. चलिए.
Afterwards,
We'll see.
Paragraph 7. This is written by judgment is authored by Dr. Sikri.
Citation would be
Citation is 2017, 9 SEC. 4 to 6, SEC 4 to 6.
okay. So you are placing this. I am marking those judgments which you are placing.
Just few lines because it's very important.
237.
May I read paragraph 7?
Just let me read it. Right. You are referring to para number
7, 7, 8, 9 onward.
7.
It was in the context of the determination of compensation, etc. So how it has traveled to the Supreme Court, and the Supreme Court found paragraph 7, it transfers from the reading of the aforesaid provision that even in the absence of examples and other evidences, higher compensation can be allowed for the other whose land was acquired under the same notification. The purpose and objective behind the aforesaid provision is salutary in the nature. It is kept in mind that those land owners who are in agriculture in most of the cases and whose land is required for the public purpose should get fair compensation. Once the particular rate of compensation is justly determined, which becomes a fair compensation, benefit thereof to be given even to those who could not approach the court. It is with this
You see,
aim.
this principle will not apply because
Yes, I
the
understand.
principle of section 23 is not applicable.
Completely. I just wanted to reflect on some humanitarian aspect, and that too by the Supreme Court. And
You rest assured that
I
we in
understand.
Jharkhand, we are very much conscious about the
I
hard realities of the
I
tribal
did-
population
I did-
and the manner in which they are deprived in many aspects of the life, uneducated, otherwise unaware of the legal aspects. So we are aware of that. So and
And
otherwise
most of-
also this is basically the compensation has to be given fair, and if there is any discretion, then it should bend in their favor.
Absolutely.
These are the basic principles, so you don't need to worry about it.
That is what I wanted to do. I'm so deeply blessed, and I'm honored to appear before this humble court. Whenever occasion comes, and you appear.
It's a pleasure listening to you.
Thank you.
I will not take much time. You have already argued against the DCP. Before coming to my written argument, I am just bring the notice of the Lord that manager 14 where the notification was issued, it starts with just one para I am just reading. Revisioning and property 1952 की धारा 8 की द्वारा 3 के खंड B के साथ स्थापित भारत सरकार व हाउसिंग एंड आपूर्ति मंत्रालय की अधिसूचना संख्या स्वयं दिनांक 8 में
Which exhibit are you reading?
Yes, exhibit 14 notification. This notification was restored by Supreme Court. By showing this page, I'm just
Last page.
yes, ma'am. Just
Page number 25.
yes, ma'am. Just to I'm just reading that because it was issued as per the Bharat Sarkar Works Housing notification, considering that notification. So this notification which was restored, neither it was challenged, nor the Supreme Court order was challenged, appointment of arbitrator was not challenged. They are not, we can't say that in our back the arbitrator was. Just wanted to, my written argument, but I personally go to more time I will not take.
Give me 1 minute. Just a minute. Okay.
Yes, my written argument personally will go over my say and stop. If not, so far as their argument that it should be confined to the only 20% who approach the
Please read yourself.
Yes, yes.
As the manner in which they have read it, and you can
Yes.
just
At the
keep
very,
explaining.
at the very outset, it is submitted that Honorable Supreme Court of India Constitutional Bench in the case of Union of India versus Kangla by Arjun Das Parekh and others reported in 1967 SCC online SC page 149 at para 6 has held that under clause A of subsection 1 of section 8 compensation is to be paid in accordance with the agreement if any reached between the owner and the government. If no such agreement can be reached, an arbitrator has to be, I am enforcing this word, but has to be appointed for the purpose in the terms of clause B. This is the constitutional bench. Further, the section 8(1) subsection A and subsection B of Arbitration and Arbitration over 40 Act, in order referred to as the Act, also says that principle and method for determination of compensation. Where any property is requisitioned and required under this Act, there shall be paid compensation, the amount of which shall be determined in the manner in accordance with the principal hereinafter set out as to say, but the amount of compensation can be fixed by agreement. It shall be paid in accordance with such agreement. Where no such agreement can be reached, the central government shall appoint arbitrator, a person who is or has been qualified for appointment as a judge of high court. It is admitted that the present case there is no document specifically on K and L available which can establish that there was any agreement between the land user and the government with regard to the actual market price of the acquired land. Since there was no agreement arrived at between the parties for determining the amount of compensation and moreover the amount paid to the land user not according to such agreement, it was bounden duty of the central government to appoint an arbitrator without any further delay. It is respectfully submitted that in absence of such agreement, it cannot be presumed that land user received the whatever compensation amount as per their free will and has given their consent acceptance for the same. In view of the aforesaid judgment of the Honorable Supreme Court and the provision of the Section 8 of the Act, there is no force or legal sanctity in the contention of the respondent inter alia that instant arbitration should be confined in respect of only land users who had preferred the writ application before the Honorable High Court and not in respect of all land users. It is pertinent to mention herein that the opposite contention of the respondent is also devoid of any merit in the light of the order passed by the Honorable Supreme Court of India in the case of Linder Mato and Union of India, civil appeal number so. It is submitted that said petition was filed challenging the order passed by the Honorable High Court of Jharkhand at Ranchi in CWJC number 2273 of 1994 dated 10/1/2008, whereby the Honorable High Court was pleased to dismiss this petition on various grounds, thus declined the prayer for appointment an arbitrator. The Honorable Supreme Court of India, while allowing the special leave to appeal, held that High Court, in our opinion, very strongly had dismissed the writ petition filed by the petitioner. Then, Lord, I have quoted paragraph 6-7.
That's it.
Leading, Lord. Then last paragraph. That in view of the opposite order, it would be absolutely wrong to say that present arbitration should be confined only in respect to the person who had filed a writ petition before the Honorable High Court. It is submitted that once the arbitrator is appointed by the Honorable Supreme Court of India to decide the risk between the parties, it would be of no use to indulge in the fact that whether the land user had accepted the amount with protest or not, or whether the land user received the full amount or 80% of the compensation amount. Once the arbitrator has been appointed, it is deemed that there is no agreement was arrived at between the parties with regard to the compensation amount. It is pertinent to mention here that no review has been filed against the aforesaid order dated 25 September 2012 by the respondent hearing. It is also pertinent that the aforesaid SLP was filed in the representative capacity the same was approved, accepted by the Honorable Supreme Court of India. In view of the same, stand ground taken by the respondent hearing that arbitrator is wrong in passing the award in favor of the all land user whose names have been mentioned found in notification 5/6/1993 is legally not sustainable, but it amount to an act interfering with the aforesaid order passed by the Honorable Supreme Court of India. That before the arbitrator, the land user have examined 4 witnesses of 4 villages, where the respondent has examined 3 witnesses about their case. Apart from the claimants have produced 5 altogether 14 documents, whereas the respondent have filed 13 documents in support of their case. It is submitted that in their deposition, all the 4 witnesses of the claimants have categorically stated inter alia their land is situated around NH33, commuting the Ranchi town. The state highway is also there. The Nampung railway station is 3 to 4 kilometers. The land of all 4 villages becomes semi-town nearby the village. There are so many industries, school, hospital, rice mill, etc. Near thereby, there is a Tata Steel railway station. In the south of the village, there is a cooker industrial area where many industries like head office, newspaper group, wine factory, office of Bijli board is existing, etc. Exhibit 1 of the claimants, that is the map of Kanpur Anchal district, Ranchi, is also reflecting that NH33 is crossing in between village Gari and the Nampung railway station, and the cooker is nearby. It is pertinent to mention herein that nothing has been put in cross-examination by the respondent controverting the said statement made by the witnesses of the claimant. Even the respondent failed to produce any document to establish that compensation amount paid to the land user was a fair amount. Whatever the statement made by the witnesses of the claimants are not correct. Before the arbitrator establishing their claim that is 2 lakh per acre, the claimants are heavily placed reliance upon Exhibit 12, the judgment passed by the Honorable Supreme Court of India, Tirumani Devi and vice versa, reported in it is submitted that said case was related to acquisition of land situated in ward number 3 of the Ranchi municipality in the year 1950. Supreme Court of India in the case passed a decree in respect of flat as follows. And I am skipping about 1,35,000. It is submitted that this document has not been taken into consideration by London arbitrator on the ground the land in the said case was situated on Ranchi Chairperson Road, which is factually not correct. The correct fact is that it is not the land acquired in the said case was situated in the main Ranchi Chairperson Road, but it was Exhibit C1 of the case, that is the land mentioned in the sale deed executed by Ranchi Clerk was on the Ranchi Chairperson Road. The arbitrator also heard in not considering the fact that the district land officer in cross examination at Para 8 has accepted that village Veri is within ward number 4 of municipal corporation. It is submitted that acquisition of land in the year 1954 situated in ward number 3, the Honorable Supreme Court passed a decree fixing the market rate of the land at the rate of 1,35,000 per acre, whereas the London arbitrator has fixed the market rate of land situated in ward number 4 acquired in the year 1971 is only 41,750 per acre. It is especially submitted that it would be difficult to believe that nearly about after 17 years, the rate of land situated in the next ward, ward number 4, the fair rate of land can only be 41,750 per acre. That the London arbitrator also had not taken consideration Exhibit 4, that is the judgment of Honorable High Court of Patna, Ranchi against Ranchi in the case of Mansoor Hassan and others, state of Bihar, dated 5 to 1990, dealing with the acquisition of land situated in ward number 5 and 6, Dorinda within Ranchi municipality in the year 1971. In the same judgment, the Honorable High Court, by taking note of the judgment of the Honorable Supreme Court in Triveni Devi was not taken consideration in that judgment. The collector Ranchi was pleased to affirm the compensation of rupees 2,50,000 per acre. The reason given by the learned arbitrator for not considering this Exhibit 4 is that land is the case was situated near the railway station and bus stand. However, the learned arbitrator failed to take note of the fact that in the deposition of witnesses of the claimant it has come that Nampung railway station is situated 3 to 4 kilometers from south of their villages, and Tati Silve railway station also exists near their villages. Hence, the reason given by the learned arbitrator for not considering the Exhibit 4 is not justifiable. That considering the fact that Honorable Supreme Court of India in the case of Triveni Devi was fixed the market rate of the land situated in ward number 3 acquired in the 1954 is at the rate of 1,35,000 acre, and further the Honorable High Court was pleased to affirm the market rate of land situated in ward number 5, 6 acquired in the 1971 at the rate of 2,50,000 per acre. It cannot be believed from any angle that just and reasonable market rate of the land situated in ward 4 acquired in the year 77 would be at the rate of 41,750 acre. That the learned arbitrator also erred in not considering the oral evidence deposition in two perspectives, especially in respect of the locality of the land and its potential value, etc., which has been reflected from the same deposition and cross-examination of the respondent witnesses, and also reflected from Exhibit 1, the map, and Exhibit 10, the yellow report. It is submitted apart from the Exhibit 1, witness number 2 of the respondent has accepted in cross-examination that NH33 runs between Ranchi and the 4 villages in question. Further, respondent witness 3 in his cross-examination has also accepted that from a perusal of copy of Anchal map produced on behalf of the land user, it appears that road connecting NH passes through the villages Tanga and Lamganj. The respondent witnesses 1 has also stated in cross-examination that between Ranchi town and said 4 villages, NH33 is situated. That the land acquisition officer Ranchi in his order report 1972 has also mentioned that agricultural land of any class near Basti and town are being used for building purposes, and as such they may be treated as a single class of land for purpose of valuation of land. Valuation on the basis of their present position and on the basis of classification in mind on the basis of agriculture would not be applicable in the case of these lands are near to Ranchi town. That apart from these two judgments, Exhibit 12 and 4, the claimants have also produced other documents before the government arbitrator. One of such documents is Exhibit 9. A perusal of this Exhibit 9, which is the same deed of 1971, it seems that same deed was executed between the known people, and the value of land has been undermined, and the same seems to be a distressed state.
How do you get this?
Lord,
You have filed it.
remember?
It was exhibited by you.
Yes,
Then you are questioning your own exhibit.
Sir, I have place many.
Then how do you say that it is between known people?
It
And how do you say
it
it's
seems, that's why I told you,
From where
the caste name is there, my lord. Their actually it was a tribal land. Then, my lord, a caste था, and then sale which caste
ये
था.
सब चीज ना थोड़ा सा सोच के बोलिए ना, एविडेंस के हिसाब से बोलिए. आप सीएलडी का कोई चीज पढ़ के कुछ
I'm
बोलिए.
leaving. I'm leaving.
What is this?
I'm leaving.
This is absolutely not proper.
I'm
This
not.
is not the way in which we read the evidence.
I'm just leaving that. May not be justified. It is particularly mentioned in Activity A. The said village Lalganj, so far as undermined, that is evidence note 13/11/1962, where the land was sold at the rate of 30,000 per acre. Considering the same, it would be highly unbelievable that after 9 years, the rate of land would be only 27,000 per acre. Therefore, Exhibit 9 cannot be taken as basis for fixing the value of land questioned at the rate of mentioned bearing very much doubtful. The learned arbiter not only are fixing market rate of land question rate 41,750 per acre, but also are not granting solution at the rate of 30%, specifically in view of the market rate given by the Honorable Supreme Court and Honorable Court in the above mentioned judgment, in view of the judgment of the Honorable Supreme Court in case reference state offers a CF.
Solation has been given at 30% or 20%?
20%.
Continue.
Article 11, which is the order dated passed by the Honorable Supreme Court India in the case of Harbin Singh Saini, Devi Union of India, reported in 1995, so has also granted solution at the rate of 30% and interest of 9%. That the judgment on which reliance placed upon by the student are not applicable in the particular case, the judgment placed by the student Union of India on the point the duty of the claimant is to oppose the competent authority raised objection with the stipulated time appointment of arbiter not blow by imposing in view of the constitutional bench judgment of the Honorable Supreme Court of India. In the case of Union of India by Kamla by Arjun Das Parekh, as mentioned herein above, and also in view of the provision of Section 8, Subsection 1, A, B of the Act, it is submitted that would not be justified to re-editate the points and placing reliance upon the judgment which were already taken by the respondent before the Honorable High Court in CWJC number 2273 of 1994, as the judgment passed by the Honorable High Court dated 10/1/2008 was subsequently challenged before the Honorable Supreme Court of India, where leave was granted and direction was passed to appoint an arbitrator by not agreeing to the view taken by the Honorable High Court. Hence, the judgment passed by the Honorable High Court dated 10/1/2008 is merged with the order passed by the Honorable Supreme Court dated 25/9/2012. So far as reliance placed upon the Supreme Court of India in case of Union of India versus Smith Munda, Smith submitted, Lord, this is my senior has argued. So I have taken, Lord, the imposed award interest. It would be very difficult for the award holder to realize the awarded amount. Judgment later would be take advantage not to deposit the awarded amount in time. It is pertinent to mention here in this case lands were acquired in 1971. Arbitrator was appointed nearly after 40 years. The award was passed 1/8/2014. There is no stay granted by this honorable court having this state award. Despite this fact, till date awarded amount has not been paid to the claimants, land user, nor the same has been deposited in the court. It is noted that I see that because I said that the principle in Arbitration Act, how the award in Arbitration Act there, Arbitration Act there, maybe Supreme Court in future it will consider that as violating of Article 14 or not.
Which portion are you skipping?
No,
Arbitration Act is not applicable.
Yes.
Yes, kindly read it, please.
Not applicable. However, the principle behind the awarding post-award interest has been laid down by the Honorable Supreme Court of India in the case of Messrs. Hyder Consulting Limited, Governor State of Odisha, reported in 2015 to SEC, and in the case of North Municipal Corporation versus SC Builders. The most of the claimants are poor, illiterate, scheduled tribe people. They may have been waiting since last 40 years for getting a just of fair market value compensation of their land, which was acquired under compulsory acquisition by Union of India way back in the year 1971. Hence, it is humbly prayed that some of the court may kindly be pleased to dismiss the appeal filed by the exploding and refuse to allow the appeal.
CPC देंगे सर.
34 below that increase to CPC.
Under the CPC, it is 6%. You have been given 15%. Now you want that this interest should be a part of the principal sum adjust, and the interest rate should be 15%.
Not in the arbitration act, Supreme Court even afford 24%.
It is not a commercial
Then I'm
arbitration.
just saying, you are deprived of, kindly see, I leave it to
Commercial contracts are very
But
different.
they are holding, I'm not leaving it because already argued. Lord, kindly see, Lord, the rule 10, sub-rule 6
Of
of acquisition of motor property.
Rule 10(6). Yes.
It is saying that on receipt of the copy of the award, the competent authorities and pay the amount awarded by the arbitrator to the person entitled to it. One submission, Lord, for my Lord.
Just a moment.
One more thing for assistance, Lord. And you see from L, Lord, how the act says, even in A also, the act says arbitration act is not applicable, but last paragraph 4 of last line of L, it says, Lord, the provisions of the Arbiter Act 1940 shall apply to such arbitration.
Which section says that the provision will not be
You
applicable?
have to say, this section,
It is under section 8
yes,
G.
yes, G. Number before coming to the judgment, one point I just highlight here. The Munsa and Sito Devi judgment both were considered by the High Court while dismissing the writ petition. Despite the fact the Supreme Court passed a direction for appointment of arbiter. On that basis, one of the ground for rejection of reliance based on Munsa and the Sito by the High Court. Lord, then judgment, Lord, I just read the relevant paragraph. My Lord, I read is first, my Lord, the Union of India by Kamlabai, that I have already read paragraph 6, my Lord, in my exposition. New Okhla, Lord, I have shown, my Lord, the factor to be considered. Then,
No,
Lord,
you just turn the judgments one by one.
yes. First judgment is, my Lord, this Constitution being judgment, where at page 20 in my marking, paragraph 6. In this case, not the very ultra-virus 8.
Paragraph 6. Read it, please.
Yes, ma'am.
Read it.
Yes. Section 8 of the Act has a marginal no principle and method of determining compensation under Clause D of Section 1 of the Section 8. Compensation is to be paid in accordance with the agreement if any reached between the owner and the government. If no such agreement can be reached, an arbiter has to be appointed for the purpose of terms of Clause B. Under Clause C, it is open to the central government to nominate.
That's what you have read it right.
Yeah, that's fine. I have already read it.
Then what
Then
is the
Lord,
next judgment?
New Okhla, paragraph 35, I have already read yesterday, to factors, 11 factors can be divided into categories. Paragraph 30, page 43 in the my mark.
Para 35.
Yes. Then Lord, page 49 is the Defense Research Development Organization. Paragraph 5 Lord, at page 53. In the imperial order, the learned Indian bench has noted that village Rajarpadi and village Madhavpura are adjacent to each other and are also covered under the same group Gram Panchayat. In doing so, they also took into account the fact that there were
Para 5 is something else. You are referring to 2014-15 SSC. 2014-15 SSC.
I guess I'm sorry. Yeah, it's 14 to 15. I'm sorry. Yes, sir, paragraph 5 at page 50.
Yes.
The High Court has adopted the method of 10% increase every year in the market value of the land and used the example to conclude that the parent cannot be permitted to acquire the land of the exponent at the price lesser than the market value of the land. The court placed reliance on earlier judgment of Union Bench of the High Court of Karnataka and made that the land was comparable to the land wherein the award dated 13/11/2022 had been delivered in Harrison Manor 263 of 1996. The land in question had a potential value on the date of preliminary notification that was evident from the oral evidence adduced before the reference court. There was no dispute that land which was subject matter as in 1986 and the land in question which contiguous and same geographical situation. After reaching the conclusion that the court, the award was given as to the value which had to be verified.
Just a moment.
In last,
Just a moment. It is not clear from this judgment as to whether there was any exemplar with respect to the same place and time. It is not apparent in this, but 10% increase was
It's the same
used.
geographical situation, stressing on that.
That's right.
Name your Gujarat Mineral Development Corporation, 2015 SSC 483, demand is more high.
Which paragraph?
Not paragraph 1, page 50.
Paragraph 1.
So that is
Page 50?
51.
Okay.
Notification under Section 4 of Navigation Act was published in respect of land page 50, for the purpose of denied credit as per Act obtained by 1988, declaration receipts of the followed are obtained by 1989. The special navigation officer awarded compensation at the rate 75 per and corresponding rupees 0.75 per square meter as per the award dated 2/3/1990 and 8/3/1990. In despite the compensation completed by the land acquisition officer, the claimants are raised dispute before the reference court, which after hearing the party increased the compensation of rupees 16.29 per square meter, together with interest and 30% solution. This was challenged by the High Court in the Supreme Court. The learned Indian has noted that village Majipara and village Burari are adjacent to each other. Their boundaries are touching each other. Nothing that compensation has been finally settled in respect of village Majipara. The division made thought is appropriate to grant compensation at the same rate. In doing so, it took into account the fact that there was no evidence showing any distinguishing feature of the land between these two villages. We have also perused the map in question and we note that two villages are contiguous to each other, have common boundaries and almost equal distance to the village Madhavpara. We may verify that insofar as the compensation payable in respect of village Madhavpara is concerned, that was granted on the basis of a sale deed in Madhavpara. We also take note that there is no evidence to show that any injustice or any illogical conclusion was arrived at in the following the compensation bill.
Why do you want to place this judgment?
I am just placing this mirror. This is the same rate mirror is contiguous.
You have already placed one judgment. But the same principle do not multiply the judgments. That doesn't really serve the purpose.
Yes.
And otherwise also the arbitrator, even those authorities, they have held that it is contiguous.
Yeah,
The same rate was adopted by even the district land acquisition
I am just
officer.
making note.
So I just put a cross regarding this judgment, 2015.
I'm just leaving all these things so that we won't.
1511 I am crossing as not pressed, right? Serial number 12. I can just delete that. Then what is the next judgment?
This is your 54. This is the Haryana State Industry Development Corporation, paragraph 22. At page 64, the learned singer will separately considered the claim of Mr.
64.
I'm sorry.
64. The learned signature. Yes, please.
Bottom of the page. Learned singer will separately considered the claim of Mrs. Kohli Holding Private Limited, which had filed RFP number 4646 of 2020, to took copies of the location of 69 Karas 15 Mudras land belonging to Mrs. Kohli Holding Private Limited, private aid, with frontage of 2 acres, the distance of the 5-star hotel and resort in the adjoining land. Learned
This
singer
judgment is that serial number?
at serial number. This is not Haryana State. This is
not
not
mentioned in the list.
serial number 5.
Right. Okay. Got it. वो sequence में नीचे कोई बात नहीं. No, it's okay. I was looking at that sequence. Anyways,
Similarly, as far as value of land owned by Mrs. Kohli Private Limited is concerned, the same has to be determined separately. This fact was not been disputed by the Indian Council or SSIBC. Rightly so far as revealing that opposite portion of 61 Kenya to 15 dollars is located on National Highway number 8 with frontage of 2 acres. Even from the back side also it has connection from the main road. It was also not disputed adjoining there to a 5-star hotel and resort. The other area adjoining to which the earlier acquired by the state in the year 1999 side, the national highway number 8 opposite the acquired land area has already been developed as housing project industrial workers. The value of land cannot be assessed merely at the rates which have been granted to the owners of the land, which is located 4-5 kilometers from national highway number 8. The aforesaid said transaction taking place 2 years prior to the issue of constitution section 4 of the Act looking at the place of development close to the acquired land, in my opinion, will reach at the rate of 50% per annum and very well be added in the value of the revenue contributed. Having the same, the value of the land will come out 1630 per square yard. The project will located about 1 kilometer inside from national highway of in the development industrial area. State and as against that, the acquired land is abutting the national highway with frontage of 2 acres, 69 km and 50 miles owned by the landowner. The value of the land on the national highway is always more as against the value of the land which is located off the road. It has its own advantage. There are certain limitations for which the land located off the main road can be used, but as far as the land located on the national highway, Mr. Ravi is concerned, it can be put on many uses through which land located on the road may not be able to be used. Considering the aforesaid as my opinion, applying the thumb rule and addition of 30% thereof can very well be added on account of special location and advantage available to the land in question, getting the same the value of the land wanting not assessed as the 1 as per that the land owners are also be attracted to this totally. Next statement. Ramesh Bhai Jeevan Roy, 2008, 14, 6747, 71 to 50, paragraph 7. The appellant urged the following contention in support of the appeal against the said judgment, Agreement 15 and Regulates at page 74.
At page 74. Yes.
The appellant, paragraph 7, bottom of the page below.
Yes.
The appellant urged the following two contention in support of the appeal against the said judgment. Agreement 15 and 16 did not relate to Jharkhand village but related to other villages, namely neighboring Santhal and far away Chalsana at a distance of 4 kilometers. Market value of land in those villages cannot furnish the basis for determining the with regard to the acquired land situated in Jharkhand. Even in Agreement 15-16 to value the basis for determining the market value of land in Jharkhand, the reference code and high court committed 3 years in calculating the increase in applying an annual increase at high rate 10% and calculating the annual increase instead of flat rate. The complaint submit the agreement was basis added and got the date of regulation and including the date of regulation of Jharkhand, how to have been calculated for 5 years for a flat rate 5% per annum. I am not facing this. Paragraph 18 said that how to flat rate should be calculated.
That's right.
Paragraph 13.
Yes.
Primarily the increased land size depend on 4 factors: situation of the land, nature of development, surrounding area, beauty of the land for development area, demand for land in the area, unless there is any prospect of development increase in price that is so steady and valuable reward in certain sports and jobs. On the other hand, in urban and semi-urban area, where the development is faster, where the demand of land is high, where there is a construction activity going on, the special market price is much at higher rate compared to rural area. We see that the big cities due to rapid development and high demand for land, especially in price have touched between 30 to 50% more per year during the 90s. Last week, in rural area,
Para 15 also continue.
yes. Normally, reports is taken to mode of determining the market value by providing appropriate escalation over the proved market value of nearby land in the previous years, as evidenced by sale transaction location, comparable land neighborhood. The sale method is generally safe where they relied on sale transaction location facilitate the subject action by only a period that is approved.
No, where there is no evidence of any contemporaneous sale, transaction or acquisition of comparable land in the neighborhood.
Yes.
One has to shift to other places only when this is absent. That is up to 4 to 5 years you can just take
Yes,
care
that's
of
why I'm
it.
not placing.
It is unsafe even if it relates to the neighboring land. What may be reliable standard, if the gap is only a few years, may become unsafe and unreliable standard where the gap is larger.
Yes.
For example, for determining the market rate acquired in 1992, adopting the annual increase method with reference to a sale or acquisition of 1970 or 1980 may have many pitfalls. This is because over the course of years, the rate of annual increase may itself undergo drastic change apart from the likelihood of occurrence of varying period of stagnation in prices or sudden sprouts in the prices affecting the very standard of increase. You just read para 16 also.
Yes.
Much more unsafe.
So the same thing to define the market requirement when it comes to the future sale transaction operation. To restrict the market line requirement to determine the year sale transaction activity and date of transaction specific voting sales acquisition future sale of the year 1994 95% replace by the market value 1991 by making reduction at the rate of 10 to 50% per annum. All are the same amount of movement of customer operation transactions subsequent to the acquisitions of the unit for determining the market value. As the very acquisition of the development of facilitated the overall development surrounding area, resulting in certain scope infrastructure scope revenue or new development activity in particular area. The acquisition in marketplace area will be slow and new importance of land area acquired for residential, commercial, industrial layout. There will be found development improvement in the infrastructure amenities facility based on 2 years the rate of this and becoming more valuable. Even if there is no actual improvement in infrastructure, the possibility of improvement of the proposed residential commercial industrial layout will get a higher rate of acquisition price. The result the annual increase market rate price from 10% per annum before the acquisition. The annual increase of market value of that area neighboring farmland will become much more significant. 30% can be more on account of development, proposed development. Therefore, it is percentage to be added with reference to previous acquisitions and transaction 10% per annum. The percentage will factor to that market value with reference to the future. Acquisitions and transactions should not be 10% per annum but much more. The percentage of suspended increase becomes unreliable. Court should therefore avoid transaction market value with reference to subsequent future transaction. Even if it becomes inevitable, there should be a greater portion of time and price based for transaction and future fee that may.
So, the
Same
court
road.
has said that this back calculation and front calculation is not a scientific method
That I am only placing that only.
because the learned arbitrator has adopted this method.
I
So you need to address to it. You need to address to it. Or you say that, yeah, you leave it to the court and so on. Then I'll see what is to be done. But the method that he has adopted, the reason I am putting this question to you is, that if we do away with that method, the compensation will fall. The compensation increased because of that method. 10% increase with reference to 1952-53, and then 10% cumulative decrease with respect to 1984-85. This method is a teeth of this judgment. It is in a very, very rare circumstances thus such kind of approach can be adopted when there is no exemplar. He has mixed everything. Had he discarded all the 71 salients, I could have understood that he had no option but to do this. But that he has not done. That he has not done. Anyways, yes, please. What other judgment are you citing?
Yes, sir.
This one, 2009 appears to be a good judgment.
Yes, sir.
We just come to page number 84.
84.
Yes. When the court says positive factors,
Yes, sir.
smallness of size,
Yes, sir.
so it is a positive factor to increase the compensation or to decrease the compensation?
Page 84.
Yes. You see, the court has taken into consideration positive factors and negative factors.
Yes.
These positive factors will have an impact to increase the price or to decrease the price. Smallness of size. Smallness of size will fetch higher per square feet rate,
Yes.
isn't it?
Yes.
That this is what
Yes.
it means.
Some judgment says below where while fixing the rate of large jumps, in a given case, court can know the price given the small plot.
Small plots will be higher in price.
Generally, but
Generally.
but it's not absolute principle.
That's right.
It's not absolute principle.
Okay. You were referring to para number 7 to 9 of this judgment, or what? 2009 volume 9. 289. You are referring to para 10.
Actually,
But read para 7 to 9 also.
the well settled principle of determination of the market value of land acquired in this country will depend upon a large number of factors including nature, quality thereof. The norms which are required applied for determination of the market value of the land and listed land applicant. In given cases, the location land in particular, coordinates thereof from any road, highway would be an important role for determination of the market value, where ratings is to be in appropriate cases may be resorted to. Position of the land, particularly in the rainy season, existence of any wedding, etc., also plays an important role. A host of other factors, including development in and around the acquired land and proximity of development, will also have a bearing on determination of the fair market value of the land. Determination of the market value of the land will also depend upon the facts and circumstances of each case. Among them will be the amount of consideration necessary need or civil experience, service, student, year-over budget of dispense of increase and transaction for the land. In absence of any such example, the market value can be determined on the basis, in the case of an outside, on the basis of number of group bearing to which Dilugam Telejar, contractor of the state of Gujarat. Lord, await this court in Yemen or India, the question of determination of market value point, while determining the amount of compensation payable in respect of land acquired by the state, the market value therefore indisputably has to be ascertained. There are these different modes, therefore, the base method equivalent would be the amount which a willing purchaser would pay to the owner of the land. In absence of any direct relation, the court however may take because of various other known methods. Evidences the evidence, so therefore, inter alia would be judgment award passed in respect of the acquisition of land made in the same village or neighboring village, such as judgment and award in absence of any other evidence like the deed of sale, the report of the expert, other relevant evidence would be only reducing the value. Therefore, the contention that the Union of India or the party of the state awards do not clash with bound by law, the principle of respect the award, it may be open to the Union of India to question the entitlement of correspondent payments of the amount of compensation which statutory limitation respect thereof. It would also be open to raise other contention relying on.
I've read. What else? Which other judgment are you going to have?
I'm not facing the competition, I'm not facing. That not in the Allahabad High Court 1 at page 106, where it is said, not at paragraph 9, I'm just reading the heading.
Just a moment.
At page 106.
Just a moment. Ramkishan is a very recent judgment. Why is it that you are not placing this?
But I have not yet in judgment.
Yes, what other judgments?
Yes, madam. The blood one of Allahabad High Court judgment, paragraph 9, I was reading it over there. Page number 106, which
Yes.
blood on the proposition that the admission made by the land acquisition of they cannot back out from whatever the admission they have made.
What admissions are you relying upon?
That exhibit came blood that is stated blood that is fit for not near Basti, it's fit for the building purpose.
The finding that classification should be done away with. They said that the
Yes,
classification
yes,
should
yes,
be done away with.
yes.
No, they classified the land in agricultural and all that, but the distinction between different villages was to be done away with.
Yes. This is not one recent judgment. This is at page 125. 125, where the compensation award was not paid. So, Honorable Supreme Court, not there, said that it should not be done. It's a right, so it is not their fundamental right, but it is the human right. You cannot curtail their right, and not they have quoted one judgment. That is, I want to read at page 123.
If you are referring to a judgment, please place it.
Yes.
You just can't refer and jump to another
No,
judgment.
but that's not. Lord, page paragraph 42, 43, and 47. Paragraph 42. Lord, we get.
These are the general jurisprudence of
Yes, yes.
property rights.
Yes.
Anything in principle,
Please.
we are not non-suiting you by saying that you don't have any right to property.
No, Lord, yeah, kindly see, Lord, this judgment has been quoted in many judgments. When in Harimato, where we got the relief.
Which judgment?
Yes, Lord, the Krishna Reddy and others, at page 40, paragraph 47.
Yes.
We can vary paragraph 47, page 175. We can very well appreciate the iniquity and need of claimant to get compensation here and now. Back in 1977, 1 decade has already passed. Now the remand is another round of litigation. There will be a further delay in getting compensation. After all, money is what money was. What the claimants could have brought in the compensation in 1977 cannot do in 1988. They have not even half of it. The county experience that the purchasing power of rupee is growing. With rising inflation, the delayed payment may limit all chance of activity of the compensation. In some cases, the delay may be detrimental to the interest of the claimant. The Indian agricultures generally have no obligation to totally depend upon the land. If uprooted, they will find themselves nowhere. They are left high and dry. They have no savings to draw. They have nothing to fall back upon. They know no other work. They may even face starvation unless rehabilitated. In all such cases, it is utmost important that awards should be made without delay. The enhanced compensation must be determined without loss of time. The appellate power of demand attended or not be exercised rightly. It shall not be restored unless the award is only unchangeable. It shall not be exercised unless there is total lack of evidence. The demand is so that the appellate court may direct some interim payment of claimant subject to adjustment. So that it is the general principle. Then we learn. This judgment, Lord, paragraph 13, Lord, at page 182, 187. From the date of acquisition that has already been done. Then we learn defense state officer, they say, Abdul Salim Nawaz, at page 191, paragraph 6 and 7. The paragraph 6 at 193 million. The submission of both the parties hereto having been remunerated, we find that appeal is broadly appeal present exception of the High Court enhancement of compensation that the KT objects no respect of income judgment and order is in submission of the appeal. The High Court extra legal award of solution arbitration of the principal striking conviction awarded under the equation note. This court has previously harassing conduct to picture of the considered of the Equation Act and providing coordination therefore now are more than likely able that ODS need to make back later conclusion of the development while upholding the constitutional action the provision beyond the award of solution and interest improved notice relying upon the previous pronouncement of Arun Singh Saini Devi and found just on paper to uphold award both solution 30% 9% interest along with principal study commission where appointment of study arbiter have been delayed by 16 years. Equity is mitigated and the harshness of common law is well known common law maxim. Several benches of this court from the Rising Coast in 1993, the Constitutional Bench Union of India Tribunal in this context of the Defense of India Act 1971, Union of India Karmal Singh and thereafter in the Lava Singh Union of India have consistently applied intertwinedness the equity resting in the maximum to mitigate the harshness of their requisition statute, thereby providing for payment of interest and solution to affected disputes parties in case of extensive protection where the statute explicitly provides for neither of these MLE or others. So for the solution 30% we are for that. Then we learn in Hari Singh Khosla Milord, after even having found that the
Where is this judgment, Hari Singh Khosla?
it is Milord at page 195.
195.
They said that it's not applicable. Land Acquisition Act and the Acquisition Action Property Act, but even having hold that Milord at para 79 page 218. 218, paragraph 79.
Just a moment. 196. In Hari Singh Khosla, the solution and interest was provided.
Because there is a delay appointment of
You read the Hari Singh Khosla's judgment. He had objected to the award right at the threshold in 1971. But in spite of that, no.
on equity.
We will see on equity, but on facts it is very, very different. On facts, he objected to the award. He filed a letter that he does not. He also filed a letter that an arbitrator be appointed, but nobody was appointed. And ultimately, he had to file a repetition, and after long litigation, the arbitrator was ultimately appointed. And under such circumstances, solution and interest were also directed to be paid to him. In which other judgments the solution and interest has been paid? Hari Singh Khosla has been following.
Previous judgment, you know,
Which
it is
one? Tell
previous
us.
judgment I just read, Defense State Officer Sayyid Abdul Salim. and
Yes,
others
let us
at
see. This is at page number
191,
191.
where Hari Singh Khosla and Sarju Ram both were taken into consideration, even though
Just a moment. Let us see the facts of the case. It was acquired Form J, notification notification was published on 22/7/1971. The competent authority collector offered 39,000 as compensation. Further, collector also granted interest at the rate of 4% from the date of publication to the on amount was deposited. An amount of rupees 45,000 was deposited by SDC LA Defence in the board by letter dated such and such. Here also 75 it was deposited. Then the person who was dissatisfied with the quantum of compensation had written a letter for appointment of arbitrator, and ultimately the government appointed arbitrator on 21/10/19. Here also immediately upon deposit there is a request for appointment of arbitrator. It is not a case where the person slept over his right. He raised an objection, asked for an appointment, but nobody was appointed. And ultimately, he had no. When somebody was appointed, this is how it proceeded. And what is the?
In my case, they themselves found
Just a
out
moment,
the
just a moment,
board
please
has
hold
been
on.
committed.
Yes, I have noted that. Let us see the facts of the case. There was a requirement for reappointment of statutory arbitrator.
Yes.
Even that was not done. Maybe somebody might have died, or maybe we do not know. The arbitrator had recorded in his award that after the failure of the first arbitrator to dispose of the matter within the period of 4 months, the government took 19 years to appoint another arbitrator. Okay. Which all judgment where this solution and interest has been given?
Yes.
These are the two judgments.
Yes.
What all?
ये मिलोट this there they मिलोट exhibit.
One we have seen Hari Singh Khosla.
Exhibit 11.
The other is Defence State.
Exhibit 11. That is मिलोट Harbal Singh Sani Devi at 194. It is.
Exhibit A1.
11.
11. Okay, let us have a look at Exhibit 11 also.
That is there. Page number मिलोट what?
Exhibit 11, correct? Kindly read this.
Having regard to the peculiar facts and circumstances of the present case, and particularly in the view of the fact that appointment of arbitrator was not made by the Union of India for a period of over 16 years, we think this selected case is Muslim Act the rate of 30% and the amount of compensation and interest in the rate of 9% per annum should be awarded in the opinion. We are making this clear and regard to the fact that we have a meanwhile being amended with a view to holding solution at the rate of 30% and interest at the rate of per annum. We are accordingly disposed of work in order as per question.
In the meantime, has been amended with a view to providing solution at the rate of 30% and interest at the rate of 9% per annum. This is in peculiar facts. We do not know what were the facts of the
I
case.
know, but our facts is very clear. They themselves have admitted the fault has been committed. Notification came. I read without the motion being.
That's it. We have seen that. We have seen that. Which all judgments are there apart from these two judgments and this order that you have placed,
Yes, ma'am.
wherein solution and interest has been provided?
No.
These are the two judgments, right?
Three.
Three. One is the order.
One is the
It does
order.
not reflect anything.
Second, my lord, the judgment of my lord justice, which will give same order.
Which is that order?
Defense state.
Yes, two judgments. One is Khosla, other is defense estate. Any other judgment?
No, at present. And Sani, we have reviewed 11.
Exhibit 11.
Even
There
that
also
one-
the
my
there,
lord,
that was also defense estate.
Yes, my lord, you have just read that. Reviewed 11.
Yes, we have read it, but still, I just want to be confirmed that it is Exhibit 11, right? Exhibit 11. Oh, this one.
Just
Exhibit 11, yes.
now, one page just now.
Yes, that. These are the three orders that
My case is, my lord, for appreciation, my lord, for my lord. There is no fault of us. It was their duty. I have read the person management, it was their duty, and they have found mistake has been committed. They themselves came out of the notification. These persons are also entitled. If these persons were also entitled, so why did you not appointed an arbitrator at that point of time?
That's right.
In tribal people, they were not aware of this acquisition property act. How they will taking that you have to go.
They have not even placed the statutory report. They have not placed the statutory report. They must have prepared some report for the central government. That has not been placed on record. Has it been placed on record? The statutory report? Form K. After Form K, after the stage of Form K, they have to submit a report to the central government.
Yeah, no report has been submitted.
That report indicated informing the central government as to what ultimately happened with regard to compensation has not been produced.
Yes. Because the exhibit said only IG, AL, nothing is there.
L is the report to be furnished to the central government.
Central. No report, then nothing has been produced. That's why the legislature is very much it is your duty. We are taking poor tribal people.
That's right.
Yet one judgment, just that my lord had given reference there to that Sanichar Lakra board
Yes,
approved
Sanichar
by
Lakra.
the Honorable Supreme Court of India. That 250, my lord,
250.
page 250. For this purpose, I am the middle of the paragraph with the view of any further litigation, the matter will direct as under. The concerned land acquisition officers are equal officers subordinate to him not below the rank of Nayab Tahsildar. We shall get in touch with all the land owners and their legal representation and inform them about their entitlement and right to receive balance amount of compensation. Now,
I don't get it in your
page 250.
250 is something else.
This Sanichar Lakra
250 is Union of India versus Sitaram and others. Then I have Ajay Pal's judgment. Then I have Sachin. 258. 258.
this Sanichar Lakra that is also exhibited below High Court judgment.
Yes.
Now, my lord, this is also acquisition involved property act. Then, my lord, the last page of this order. Even the court says no, you go and open a bank account, help them, pay money. The bank account number, landowners should be given to land acquisition collector. The land acquisition collectors are deposited the check of compensation in the bank according to landowner accordingly further delay. The amount cost shall also be paid within 3 months from as secured within appeal. So court is so conscious that Sanichar Lakra has been told by the Honorable Supreme Court.
It is arising out of a different land acquisition or it is arising out of.
Acquisition property.
No. From this property only, no.
No,
It is not arising out of
not
this.
no, but the provision, I will say page 249. Yeah, allow me. He was the above conclusion who has satisfied that the direction given by the arbitrator for payment or solution association and interest do not call for interference because there was unexplained delay for more than 8 years in the appointment of arbitrator. In Babu, they are a Union of India International This Court refused to interfere with the award of solution and interest on the sole ground that there was unexplained delay in the appointment of arbitrator. So, my lord, unexplained delay, explanation which has to be given by them.
Both of you are passing to each other. They say that there is unexplained delay on your part,
Lord,
and you say that there is unexplained delay on their part. So this I have to decide who is at fault.
Act, subsequent bench judgment, and coupled with that, these two are really.
Unless it is found that Union of India was at fault, there is no question of payment of compensation of solution, because there has to be a finding that Union of India is at fault, isn't it? Correct? Is there any such finding recorded by the learned arbitrator regarding the fault of Union of India in not referring the dispute for arbitration? Has any finding been recorded?
The Supreme Court of India has said, Lord, that
No, the finding of the arbitrator. Is there any finding of the arbitrator on this? Has the arbitrator recorded as to who was at fault? Is there any finding? I am just asking you, just trying to figure out what is the finding of the learned arbitrator. This is at page number, internal page 32.
32.
Having failed in their duty,
Yes.
the respondents cannot contend
Yes.
that the land losers moved the court in 1991, that is after about 20 years of acquisition. The poor, illiterate and scheduled tribe people in the circumstances cannot be penalized if they could move the court only in the year 1991. Is there any observation of the Honorable Supreme Court that all the land losers are to be treated equally?
No.
Because there is an observation of the learned arbitrator.
Notification has been restored.
No. Is there any observation of the Honorable Supreme Court that all the land losers are to be treated equally? Because the Honorable Arbitrator is recording it.
So only if you are informed that the arbitrator appointed under the constitution no more, therefore direct the state government to appoint a new arbitrator to decide the lease between the appellant and others, also in respect of those persons who have lost their land pursuant to the notification issued by the state government.
वो तो एग्जिबिट हुआ होगा ना कोर्ट में, ये आर्बिट्रेटर के पास. कल आपने तो सारा प्लेस किया ही.
Yes, sir. We have yes. Then we are lastly including
Just give me one. If you see the map for a moment, Gari we find next to National Highway.
This is crossing in between.
Yes.
The Gadi village,
Yes.
the national highway is in middle of the Gadi.
Yes, in middle of Gari. But what about other villages?
This is the near.
This is Kutanga, Lalganj, and Sulu.
Shuni,
Kutanga, Lalganj, and Sulu. It is near National Highway.
state highway. This is national. How far it is not.
Gari is National Highway, right? This you have already stated. It has evidence. It has come that
Gadi.
Gari passes. National Highway passes through Gari. But what about the other three villages?
Ganga, Lalganj and Sulu.
Sulu.
Is more near and they are
From the other end. From the other end.
the state highway.
And through the state highway, this area is also connected to the national highway. So they are all in the vicinity of national highway.
Same.
And so far as ward number 4 is concerned, all the properties are in ward number 4. It is not in dispute.
Yes. My submission would be, my lord, that my lord have read this city judgment and other document my lord have pointed out. Even the court has power. Less amount than that claim to court is hands are not tied. In the interest of justice, even court can go beyond the claim. So I leave it to my lord. I just we are poor tribal people. Whatever who are possible things we have proposed. Supreme Court will not say they should not tell one line kindly leave and conclude.
But the order by which the Honorable Supreme Court has appointed the arbitrator, I just want to have a look at it once more.
Yes.
Virendra Mehto,
Yes. Paragraph 6 will not.
just a moment.
The language my lord tells you.
Just a moment. That's right.
Kindly see not only is paragraph 7 in view of the above. What the Supreme Court has found, in the matter of this nature, in our opinion, the good conscience should have prevailed on the respondent who have accepted the reasonable request.
That's right. I noted that.
Not matter of this nature, but I give it to my lord, whatever the amount the my lord have already expressed, whatever the fair and just. mock solution 30% is but there was no fault of us.
That's all.
Yes, deeply over.
अपना अपना एक्सपीरियंस जो भी लोग एप्लियर हुए हैं
Yes.
और जो नहीं हुए हैं उनका एक्सपीरियंस प्लीज मत दीजिएगा. I don't record their appearances. Those who have not appeared, please do not give their appearances.
Deeply obliged for giving so much of time. We are not getting this much of time in
I am never in a hurry. Every case is important
I have seen
and it is dealing with life.
yes,
एक केस जल्दी करने के चलते दूसरा केस हम हरी अप नहीं कर सकते. During the course of hearing, 2 judgments were cited. कौन-कौन से वो judgments थे उनको अलग से रखना पड़ेगा इसमें. I'm just editing my files. During the course of hearing, 2 judgment, एक आपने साइड किया था, एक आपने साइड किया था. आपने कोर्स ऑफ हियरिंग में कुछ एक जजमेंट साइड किया था जो आपके उसमें नहीं था. कौन सा साइड? हाँ, ये सेनेट मुंडा. वो तो पहले भी साइड किया था. आज रिटन सबमिशंस फाइल होने के बाद कोई जजमेंट साइड किए थे क्या? नहीं. जो रिटन सबमिशंस में है वो है काफी.
Sanat Munda is also there on your page number 72
ठीक.
in compilation.
one already argued by my senior.
Yes, you have.
I only one thing, my lord, I don't know, my lord, what is there. I kindly take note of my this last submission. Even it was stated that we are not entitled for that. My respectful submission will be not only the quality of body. Other persons, Lord, the arbitration will be there. Maybe this point can be raised one day. Good consensus, Lord. Other days bench. Lord, had it been acquired.
देखिए, I will not exceed my jurisdiction.
Had it been acquired in the land division.
At best, you can say with that content order that is not the point before the Honorable Supreme Court for consideration as to what would be the rate of interest and how it would
We
be
are
done.
very happy, my lord. We are not money how to go Supreme Court, my lord. Since I am there, somehow I am taking. Otherwise, they can't go, my lord, about to go Supreme Court.
You see, now nobody can say that they are poor and they can't go because the government has provided enough legal aid to
Yes,
everybody.
that is, my lord, general legal aid is.
Enough legal aid, nobody can say that I can't go to the Supreme Court.
But despite this fact, I have seen, you are seeing the Supreme Court. So,
That's it.
like,
So what is to be done? I will not reserve the judgment.
yes.
I am concluding the argument, but I will dictate it in the court. If you want to come, you come. If you don't want to come, you do not come. Partly I will dictate in my chambers, and partly I will dictate it in the court.
If possible, I will-
CAB is,
It will
you
be
know.
my privilege to appear.
No,
again.
if you come, it's okay. There is not at all required. I will not allow you to speak anything.
No, I will not speak. No, it's concluded. It is the my lord's
I
verdict.
just
It will-
wanted to, you know.
We are waiting for my lord's verdict. Last,
So-
my lord.
Correction will certainly take its own time, but I will decide it in the court.
Almost, my lord,
I will do some homework over the weekend.
71 will have more than 40 years.
I have been just telling them before anybody else dies, I should decide the case. This is my whole endeavor in doing these
More than
matters.
40 years.
I ये जो है ना सेकेंड हाफ का जो हम लोग नोटिफिकेशन देते हैं ऑर्डर्स के लिए और उसके लिए वो 3-4 दिन के लिए पास कर देना है. वो नोटिफिकेशन नहीं देना है. ये वाला जजमेंट जो है 4 बजे तो ऑर्डर्स के लिए रहता है. ये कुछ ऑर्डर्स जो भी टेकअप हो जाएगा वो हो जाएगा. 2:15 बजे से लेकर 4 बजे तक 2-3 दिन लगेगा, लेकिन लिखा. ठीक है. तो इट विल बी फॉर डिक्टेशन at 2:15 from Monday onwards till I finish. साथ साथ करेक्शन करते रहेंगे, साथ साथ कुछ अपना होमवर्क भी करते रहेंगे. लेकिन आपको वो सॉफ्ट कॉपी नहीं दी है. हमारे स्टेनोग्राफर का काम कब देंगे आप? How much time do you need to provide the soft copy?
And over.
हाँ अभी क्योंकि अभी चेंबर में जाके यही करना वाला
Cost should be imposed upon
हमारे यहाँ कॉस्ट
the young lawyers should all
आपने सिखाया नहीं ना कॉस्ट आपके ऊपर होना चाहिए
हमारे भगवान ये तो हाईकोर्ट में practice करते हैं।
तो आप क्यों बोल रहे हो उन पर कॉस्ट हो जाना चाहिए
My lord,
यहाँ पे लोगों ने नहीं सिखाया तो उनकी गलती है नहीं ना
it's the lighter side.
यस ये भी इवन आई एम ऑन द लाइटर साइड जूनियर पे कॉस्ट नहीं होता है कॉस्ट हमेशा उसके सीनियर पे होता है
Very good.
किसके पास काम नहीं है सॉरी हु हैज गॉट द लीस्ट वर्क अमंगस्ट यू
बता देंगे देख कर बता देंगे
You are not coming PC link, we can be.
हाँ yes you can join on BC link you need not come there is no problem ये around 200 cases हैं 400
Here, many person not able to come to court.
we don't bother about this those who have not been able to come
Lord, being a court officer, I am just saying, Lord, there are judgments, Lord, they have not have come. When in criminal law and in this footage, that equal.
अब आपने आर्गुमेंट कर लिया अब आप कुछ मत बोलिए मैं क्या रही है
Like.
Arguments concluded.
I'm deeply obsessed.
Post for dictation of judgment in open court at 2:15 on Monday. आपने दे दिया सॉफ्ट कॉपी
Cost item का दे दिया है.
कॉस्ट टाइटल कर दे दिया अब उसके अलावा
This also my lord.
डिले नहीं करिए प्लीज आप प्रोवाइड करिए हमको अभी चाहिए हाँ अभी चाहिए हमें 4:30 बजे के पहले लीजिए भाई इनसे कॉपी करिए और इनका पेन ड्राइव इनको वापस करिए लेके नहीं रखने का है अब पेन ड्राइव का भी कॉस्ट कितना होता है 250 रुपीज तो होता ही है ना वी विल नॉट कीप इट
This one is specifically dedicated for this case.
This pen drive is only for this case.
Because we had done a lot of communication of PCR and other things, so this was dedicated.
हम लोग बहुत दिनों से इस पे लगे हुए थे मतलब it was like getting the case ready for hearing was itself quite a task.
I'm told that my lady has put up so much effort was to allow a substitution.
All substitutions, all delay condoned, everything. I just thought that I cannot dismiss this case on account of any delay from either side. Substitution, long substitutions, all abatements set aside, and the councils have also really cooperated.
I'm told that my
Preparation of the cause title by itself is quite a task.
Have a task. Then it is the substitution.
आपने अब तक कॉस्ट टाइटल ठीक से बनाया है ना?
Yes, with their consent.
हाँ?
With consent of others.
दोनों के साथ मिल के बनाए हैं? स्पेलिंग मिस्टेक वगैरह नहीं है? वैसे सारे सब्स्टिट्यूशन में मैंने यही ऑर्डर किया है कि ओनली फॉर द पर्पसेस ऑफ दिस केस अगर मान लीजिए वहाँ कोई आइडेंटिटी प्रॉब्लम होगा तो द एग्जीक्यूटिव कोर्ट विल टेक केयर ऑफ इट वी जस्ट कांट से एनीथिंग मोर
Really appreciate my lady has put up so much effort.
let's see how does it come up.
It's very Herculean task then to comprehend the issue paper wise because it's the first step. We can't ignore any single document.
Certainly. Okay.
I'm so deeply impressed. So
इसको अलग रखिए ये बंडल इसको अलग रखिए और ये पूरा बंच है ये बिल्कुल ही अलग रखेंगे है ना गोराई जी इसमें जितनी भी जजमेंट्स हैं जो पैराग्राफ रेफर्ड हैं कुछ केसेस में हमने कुछ एडिशनल पैराग्राफ डाला है वो सारा आप एक साथ एक जगह कर लीजिए इनके सबमिशंस की सॉफ्ट कॉपी आई है, वो सारा कुछ एक जगह कर लीजिए और जो पार्टी पोजीशन है उसको एक जगह कर लीजिए, ठीक है? ये सारा जो एविडेंस है वो यही है, बाकी हमें ज़रूरत नहीं है किसी, है ना? दिस इज इट, सारे ओरल एविडेंस और जो डॉक्यूमेंट्री एविडेंसेस है इसमें। किताब साथ में रखिए।
Supplemental is for hearing under the 41 Rule 11 Action 410, second April 98 of 2022.
Have you prepared your note?
Yes, I have prepared my notes. My notes are ready. Notes are ready, let's get to this.
So you have not prepared it for me?
So sorry, but
ऐसे नहीं होगा, बहुत फैक्ट्स आपके पास।
facts तो बहुत है.
तो हम कैसे सब्सटैंशियल क्वेश्चन ऑफ लॉ बनाएंगे बिना फैक्ट्स को समझे? ऐसे कुछ भी बना देने से बहुत प्रॉब्लम होता है।
I understand.
अल्टीमेटली जब एडजुडिकेशन होता है तो पता चलता है दिस सब्सटैंशियल क्वेश्चन ऑफ लॉ डज नॉट अराइज एट ऑल, देयर इज समथिंग एल्स व्हिच इज ट्रबलिंग द पार्टी। ऐसे नहीं हम सब्सटैंशियल क्वेश्चन ऑफ लॉ बनाते। यू कम नेक्स्ट वीक, आई विल नॉट पास एन ऑर्डर लाइक दैट। ऐसे मैकेनिकली सब्सटैंशियल क्वेश्चन ऑफ लॉ नहीं बनाते।
बहुत सारा इनके कोर्स से लेकर अभी तक का है ये प्रैक्टिस।
आपका काम है, दैट्स अ पार्ट ऑफ योर जॉब।
I know it. I know.
हम बोल सकते हैं 54 से अब तक का कहानी नहीं लिखेंगे, नहीं बोल सकते ना
नहीं बोल सकते।
इन एनी केस।
नहीं बोल सकते।
इट्स अ पार्ट ऑफ योर जॉब। आप जितना बढ़िया से अपना नोट बनाएंगे उतना अच्छे से सब्सटैंशियल क्वेश्चन ऑफ लॉ बनेगा। ऐसे नहीं बना सकते।
Yes. Yes.
बनाएंगे आप नेक्स्ट वीक आइए, वी कांट डू एनीथिंग। It will come in the next week. Counsel for the appellant seeks adjournment to submit a note on this court.
But after test him, because just now.
Thursday?
Thursday.
December. From daily list for the Saturn 13, second appeal 163 of 118.
The last copy. I have served copy on the office of Advocate General and asked for serving. And the respondents have appeared. They were asked to file a supplementary affidavit. They were able to file, bringing on record the legal ends of respondent number 1 madam who is appointed to file. So they have filed a supplementary affidavit in compliance with my law's order.
So what do you want?
And that
You have to file substitution or what?
they have taken permission because the respondent has right others. And my lord said asked.
No, being the appellant steps has to be taken by you.
My lord,
Have
I
they
have
given
an
you the-
objection to the supplementary affidavit, so I will just come to that point that.
So you have to file your objection in writing.
My lord, because they are bringing one new person, absolutely new person who was not a part of the appeal also, and that person is being brought on record right now that he should be pleaded as a part of this problem.
I have not stated that he should be pleaded.
ये supplementary affidavit नहीं है यहाँ पर। If you have objection, you have to respond in writing. You will not take
And
oral.
I'll file it.
इसके
It
लगाएंगे।
anyways cannot be done, Your Ladyship, because he was not a party before the learned appellate court as well.
That is paragraph 8 of the supplementary affidavit that is filed at page 3.
Record सकता?
Yes.
You want to argue or you want to file a response?
I'll file a response. I'm objecting to the affidavit that they have filed. Specifically, paragraph 8, they have mentioned this.
Counsel for the Appellant seeks adjournment to file a response to the supplementary affidavit filed on behalf of respondent 23. By what time?
2 weeks.
At the request, the matter is directed to be posted on 4th of December. ये सारा जो है ना एफिडेविट इसमें लगा देंगे.
Item 14 CMP 1078 of 2022.
What is this CMP for?
It's an IE, madam.
I
As
will
per the notices were issued, madam, to respondent number 28, and one of the legal heir, Dileshwar Saw, has received the notice. Rest of all, madam, no address has been found, madam. So an IE has been filed in light of the last order, madam, for publication.
What is that IA? 8059
Yes, madam.
for substituted service of
Yes,
notice.
please.
On respondent number
Proposed
28.
legal
Proposed legal years of respondent number 28.
28. There are para 7, madam.
Para 7. One of them has received the notice.
Yes. Dileshwar Saw, that I have needed in para 7 itself.
Dileshwar Para 7.
The IE.
Dileshwar Saw, who is also one of the legal
Yes,
years.
we received.
Who is appearing for Dileshwar Saw? Are you appearing for Dileshwar Saw? Anybody
I
has
was
entered
appearing
appearance? Nobody has entered appearance. इनका दिलेश्वर साहब का भी नाम इसमें डाल दो. That would be better,
Madam, I know that.
right? कि जब करना ही है तो उनका भी include कर दीजिए. ठीक है?
It may come on order में आ जाएगा.
Order में
Yes,
करें. CMP number 1078 of 2020. The learned counsel for the parties are present. The counsel for the appellant has submitted that notices were issued upon the proposed legal years and successors of respondent number 28. In connection with whom the substitution petition being IE number 1504 of 21 was filed. The name of the respondent number 28 is
Fuleshwari Devi.
Fuleshwari Devi. He submits that notice has been served upon one of the legal heirs, namely Dileshwar Saw, and through this interlocutory application, being IE number 8059 of 25, a prayer for substituted service of notice to the other legal heirs and successors has been made. He submits that Dileshwar Saw as well as other legal heirs and proposed legal heirs and successors of respondent number 28 are residents of Ramgarh in the state of Jharkhand. After hearing the counsel for the appellant, the petition for substituted service of notice upon the proposed legal heirs and successors of respondent number 28 is allowed. Let the name of Dileshwar Saw, who is said to have received the notice, be also included for the purposes of substituted service. As he has not entered appearance in this proceedings, the counsel for the appellant shall furnish the draft notice for publication in the registry within 1 week. Within 2 weeks, the registry is directed to verify the draft notice and give it to the counsel for the appellant for publication within 1 week thereafter. Supplementary affidavit. The publication we made in newspaper, Prabhat Cover, एक दो पेपर होना चाहिए.
प्रभात और
दैनिक जागरण and दैनिक जागरण having circulation in district of
रामगढ़ सर.
रामगढ़. ये लोग रामगढ़ में रहते हैं. In the district of Ramgarh. The supplementary affidavit regarding the supplementary affidavit annexing the newspaper we filed before this court by 6th of January. 6th of January. Post on 6th के बाद वाला जो भेजा है दिखाइए. Post on 22nd January. पेपर जो है ना कटिंग मत लगाइएगा. जो पेपर आपका पब्लिकेशन जहाँ पे हुआ है वो पेज पूरा है. आइए डिस्कस. एक और भी है. एक्सक्यूज मी, देयर इज वन मोर. आइए.
Sufficient for 28.
ये तो 28 का ही चल रहा है. ये तो सब्स्टिट्यूटेड सर्विस के लिए. आइए हम लोग तब अलाउ करेंगे जब नोटिस कंप्लीट. अभी नहीं कर सकते.
Item 15 CMP 1378 of 2023.
Yes.
ID number 5564. Two parties were made not to be included in the restoration.
This is for what?
This is for restoration of.
No, this IA is for what?
I is for aiding the party. Two persons were left to be included in the
memo.
Yes.
In the cause title.
Yes, Lord, in the cause title of the restoration petition. In paragraph 4, I have mentioned there.
There were parties in the essay. There were parties in the essay.
Yes, there were parties in the essay, but by mistake they were left to be included in the CMP. Therefore,
IA number 5564 of 25. To this IA.
There is a delay of 418 days.
We'll see that. First, IA to change. Correct.
The notice will have to be checked. There is a huge delay since
You are
beginning.
you are representing whom?
I am representing respondent number 1 and 2.
1 and 2. IA number 5564 of 25 in CMP number 1378 of 2023, arising out of essay number 222 of 2017. This petition has been filed seeking to add two persons, namely Saroj Devi, wife of Suresh Ram, and Suresh Ram, son of Aklu Ram, as respondent number 3 and 4 होगा ना?
yes, 4.
5 लिखते हैं. 3 and 4. In this petition seeking restoration of the second appeal, the learned counsel for the appellant has submitted that the aforesaid two persons were parties in the second appeal, and on account of mistake, their name could not be included. Inclusion में तो आपको कोई दिक्कत नहीं है.
नोटिस होगा तो
नोटिस होगा, certainly नोटिस होगा.
डिले बहुत है तो इनके सपोर्ट में है. और since 99 the case is being delayed.
The learned
At
counsel
every
for the respondent has submitted that if this petition is allowed, the notice has to go to respondent number 3, that up to the two persons, namely Saroj Devi and Suresh Ram. ऐसे दिखाइए, ऐसे दिखाइए, ऐसे.
Since we have filed the joiner also. Since beginning we are delaying this case. Since 1999.
अभी आपको बहस करने बोलेंगे ना तो आप तैयार नहीं होंगे.
मैं तैयार हैं.
There is the memo of appeal of the essay considering the aforesaid submissions. IA number 5564 of 25 is allowed. The counsel for the appellant petitioner is directed to insert the names of Saroj Devi and Suresh Ram as opposite party number 3 and 4 respectively, whose details have been mentioned in paragraph 4 of the executive application. ये क्या आप ही के फ्रेंड्स हैं? कौन है?
They are
आपके रिलेटिव हैं?
relative to vendors. ये Wendy है.
Oh,
Wendy है.
just a moment. Let notice be issued to the newly added opposite parties. आइए कहाँ है आपका? ये तो एडिशन का आइए है ना, डिले का आइए कहाँ है? Combination of delay?
2518.
In IA number 2589 of 2024 and also in the main CMP, for which requisites be filed within a period of 2 weeks from today. Print. Use speed post. Speed post. Office to track speed post delivery. Post this. Only speed post. नहीं चलता है क्या speed post? Ordinary भी करना है. कहाँ के रहने वाले हैं लोग? And also through ordinary process. Speed post and ordinary process. Post on 6th of January. Sorry? आप कर लीजिए. उनको लाल कलम दीजिए और उनको कर लीजिए. ठीक.
Item 16 CMP 150 of 2024.
Yes, applicant.
When pursuant to the last order, notices were issued to the substituted, proposed substituted hires. So now what I face is the limitation petition is on board and there is also a substitution petition. And notices were sent on both of the hires. So probably the report would have been received.
So, what is the report?
Because I could not see the report.
Item delivered.
Civil section से report नहीं आया, लेकिन tracking consignment says that it has been done.
But nobody has appeared.
How much is the delay? This is restoration
Yes,
of second appeal.
this is restoration of a CNA which was filed against a restoration of a WCC. So what has happened when we have preferred in earlier CMP, it came to our knowledge that already a CMP has already been filed and it got dismissed. So we took liberty from the honorable court to get this earlier CMP restored. And hence the delay is also 743 days because of the continuation of the earlier CMP, 600 and odd days it goes in there.
IA number 8475 of 2025 with IA number
3179.
किसका सब्स्टिट्यूशन आप मांग रहे थे?
The private respondent, number 6,
नाम?
Jharkhand Mandal.
इनका तो डेथ सर्टिफिकेट आ गया है 26/1/23. इन्हीं का सब्स्टिट्यूशन आप मांग रहे हैं ना?
जी.
और कॉन्ट्रिब्यूशन ऑफ डिले कम है?
Condemnation is the first IA. 313 is numbered as 3179.
31?
79.
This is for condonation of delay in filing the substitution petition.
No, in filing of the CLP, the main CLP.
In filing of this means.
And if the petition files an action set A attached to that IE. That was my earlier CLP. Page 7 to my the IE.
पहले तो आपका substitution allow करें.
जी.
इसके बाद ही वो
There are two survivors.
दोनों में notice किया था.
दोनों में.
I number 8475 of 25 in CAT number 150 of 2024. Learned Counsel for the appellant has submitted that notices were issued to the proposed legal years and successors of respondent number 6, Jagannath Minda. As per the speed post tracking report, the notice has been served, but nobody has entered a clearance. Considering the averments made in the interlocutory application, the petition seeking substitution is hereby allowed. The counsel for the appellant is directed to insert the name of the legal heirs and successors of respondent number 6, whose details have been mentioned in paragraph 3 of the interlocutory application in writing during the course of the hearing. इसके बाद ये लिखिए IA number 3179/25. This petition has been filed for condonation of delay in filing the petition for restoration of CAT number 387 of 2018. Which was dismissed on account of non-removal of defects within the stipulated time. There is a delay of 736 days. The counsel for the petitioner has referred to the averments made in paragraph number
So
5 to
5 to
9.
8. Yeah.
5 to 9 of the interlocutory application. Upon going through the averments made in the interlocutory application and being satisfied with the cause shown, the IA number 3189 of 25 seeking condonation of delay in filing the CAT petition is allowed. अब मेन वाला मैटर में होगा
So page 13 to my CLP, that is the
लेकिन CAP में तो नोटिस नहीं है.
CLP notice. So it was
Just a moment. The CAP number 150 of 24. Let notice be issued to the respondent number 6A and 6B through speed post
through speed post
and also through ordinary process,
within 2 weeks.
for which requests be filed within 2 weeks. Office to track speed post delivery. Post the CLP under the heading, under appropriate heading on 12th of December. नहीं 2 हफ्ता तो आपको नोटिस ही फाइल करने के लिए चाहिए. 19th.